Can an accused rely on the defence of being drunk or high on drugs to a sexual assault charge? In other words, can being voluntary intoxicated or high on drugs give rise to an accused reasonable belief that the complainant was consenting to a sexual encounter when they were in fact, in quotes, honestly mistaken? What does the law say about mistakes by an accused about a complainant's consent because the accused's decision making was affected by alcohol or drugs? This was one of the main issues in the case of R versus Grewal, a very interesting case where the facts are all too common in life, in a police station interview of a suspect, and during a criminal trial. Let me tell you about the elements to prove in a sexual assault case, the facts of Grewal, and what was decided in the Court of Appeal on whether being drunk can help an accused in defending themselves to a sexual assault charge. The law on sexual assault requires A. intentional touching, B. the touching is sexual, and C. to consider consent from two perspectives, the complainant's perspective and the defendant's perspective. Assuming the facts of a case is that the only issue is about consent, the first question is, did the complainant consent to being intentionally touched? If the answer is no, the complainant did not consent to being intentionally touched, the second question is, did the defendant reasonably believe in the consent of the complainant to being intentionally touched? Now, in answering that second question from the defendant's perspective, the law says the court should also consider this. Whether a belief is reasonable is to be determined having regard to all the circumstances, including any steps A has taken to ascertain whether B consents. Now, legally, can a defendant argue that his self-induced voluntary intoxication could give rise to his reasonable belief in the consent of the complainant, where the accused argues their belief in consent was an honest one, but ultimately accepts it was mistaken? Let me give you the brief facts of the case of Grewal to give you some more context. The defendant and the complainant were both students. Both were very drunk when the defendant attempted to have sex with the complainant. The complainant testified that she was not consenting and made her objections known to the defendant, who ignored them. The defendant countered that this was not true. He argued that either the complainant consented or he reasonably believed she consented up until a later point whether the complainant asked him to stop, and he did. The defendant was convicted of sexual assault. He appealed his conviction on various grounds. Now, one of the grounds was that the judge had misdirected the jury on the issue of how to assess the defendant's belief in consent, given that he was drunk. The defendant's point was this: in deciding whether he had a reasonable belief in the consent of the complainant, the court should have given directions to the jury to consider his circumstances, including the fact any mistake he had in consent of the complainant could have arisen from being voluntarily drunk. The Court of Appeal rejected this and other arguments. The jury had been properly directed that intoxication was not relevant to whether the defendant had a reasonable belief in consent. The Court of Appeal made two very big points. One, voluntary intoxication should not be considered as a circumstance for assessing whether a belief is reasonable under Section 1(2) of the Sexual Offences Act 2003. In other words, a defendant's self-induced voluntary intoxication cannot give rise to a defendant's reasonable belief in the consent of the complainant in any circumstance. And two, when deciding whether the defendant reasonably believed the complainant consented, one has to look at the matter as if he were sober. To emphasize these points, while intoxication might explain why the defendant had an honest belief in consent, it is not relevant to whether that belief is reasonable. The reasonableness of his belief is assessed from the perspective of a reasonable, sober person. Now, this case is important for obvious reasons and highlights that being mistaken about consent arising from voluntary intoxication and, by extension, being high on drugs is not a factor a jury should ever take into account, and so is no defence. Feel free to comment, follow, like and share.